Yes.
All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. Welcome to the Court of Appeals. This is case number CAIC130033, Calder versus Interstate Zurich. For the parties' information, these proceedings are being recorded. As you approach the bench, please state your name and who you are representing. The recordings are both audio and video, and hopefully if the machines work correctly today, you will be on YouTube in a couple of weeks. Each side will have 20 minutes to present your argument. Appellant, you may reserve a portion of your time for rebuttal, but you have to keep track of your own time. But if you'll tell us how much time you want to reserve for rebuttal, we'll try not to horn in on your time past that. We have read the briefs, discussed the case in conference this morning, and read through relevant parts of the record. So the clock on the podium tells you how much time you have left, and for appellants, if you want to reserve 5 minutes for rebuttal, and the clock says 10 minutes, that includes your 5 minutes of rebuttal. So with that in mind, you may begin.
Good morning, Your Honors. Ronald Ozer and Joseph Bettini for the petitioner Kelly Calder. May it please the Court. The award in this case, Your Honors, should be set aside for two independent reasons. Number one, the record contains insufficient evidence to support this loss of earning capacity award. And number two, the administrative law judge erred by failing to explicitly resolve several material and important factual disputes. The first issue involves whether the ALJ's finding that employment was reasonably available to a claimant is supported by the evidence. And the initial burden of proof with regard to this issue is on the claimant. The claimant clearly met that burden by conducting a massive job search with submitting over 157 applications, also presenting expert evidence on this issue that she had a total loss of earning capacity. And therefore, the burden shifted to the employer to bring forth contrary evidence. And under the Zimmerman case, what the employer's burden is to show a reasonable probability that this claimant can find suitable employment on a regular basis. The Zimmerman court also says that the employer must show evidence of job opportunities, in the plural, that employment is suitable and reasonable for this claimant. Now here, the ALJ's decision, the administrative law judge's decision, explicitly finds that the claimant's geographic labor market includes only Williams, Arizona, and not Flagstaff or Kingman or Farmington, New Mexico. And she found that full-time employment as a ticket agent or sales office clerk in Williams, Arizona would be suitable and available. The problem with that finding, Your Honors, is that the defendant's labor market expert clearly stated that the sales office clerk position was in Flagstaff and not in Williams. And so the judge erred in finding that there are two positions in Williams. It's really only one position, and we're left with one position, this ticket agent position, on which this award can be based, this single position. And it is just, that evidence is just not substantial enough to establish or to base this earning capacity award on.
So Mr. Ozer, is it your position that if there were two jobs in Williams, that would be sufficient? Or would it take 3 or 5?
I think it depends on the facts of each case. 2, I would submit, would not be sufficient either, but 1 is even less sufficient, and especially under these facts, which I'm going to go through in a minute, that clearly they haven't met their burden of showing a reasonable probability that Ms. Calder would obtain this employment on a regular basis with just this one single position in Williams.
Is that I'm sorry. Is that because she actually applied for that position and was turned down for some reason?
That is one of those reasons. And, Your Honor, she didn't only apply, but over the course of 3 years, she submitted approximately 12 applications with this very employer, the Grand Canyon Railroad, and she submitted an open application, and she never even got an interview over the course of all these applications and 3 years of applying. For whatever reason, the Grand Canyon Railroad didn't want to hire her. And I don't think this analysis should be divorced from the real world. This job was not available to her. On this record, I don't think anyone can say that it's probable, likely, that on a regular basis she's going to get it when she didn't get it over the course of 3 years and 12 applications.
Can I ask one other question? And that is, in this record, do we know whether Grand Canyon Railway accepted employment applications only over the internet?
I don't know if we know on this record. My recollection of the record, Your Honor, is that the applications were submitted on the internet. I believe that the claimant testified at the hearing that that's the way that applications were submitted at most of the employers in this day and age, and so she did it that way. But I don't know, Your Honor, if that's in the record.
Been a victim of the dreaded internet screening, employment screening, anonymous screeners.
Well, she may have been. She received email denials with regard to the Grand Canyon Railway job, and that's all she received, and never even an interview. And so she, that job, she never really came close to obtaining that employment.
Is it necessary? I'm sorry, did I cut you off?
No.
Is it necessary to show that there is an open job that she can go grab right now? Or is it just necessary to show that there are jobs in the area that would be available to her given the limitations of her disability?
Well, I think it's a rule of reason. And the Arizona Supreme Court has said in Zimmerman that when opportunities narrow, it's often the injured worker that's the last hired and the first fired. And I think what that statement by the Supreme Court means is that we need to look at the real world. One singular position is a pretty narrow opportunity, and especially in light of the 157 job applications, the 12 with this very employer, and that she didn't even get an interview, and And there is really nothing more that this individual could have done to get a job. She's injured in '05, Judge. She goes back to the date of injury employer until she's injured again on her back. Then she asks for light duty with that employer. It's not available. She then goes back. She gets employment with a trucking company delivering fuel, a different company. She does that in '06 and '07 until she runs out of medical leave and is fired. Then in '08, she starts this massive job search with 157 applications. In '09, she voluntarily goes to vocational rehabilitation to try to become a medical assistant, but has trouble with the keyboarding because she's had 5 surgical procedures on her hands, and unfortunately did not obtain a job during the relevant time period. And so I think you look at the totality of the circumstances, you look at the efforts and what the employer has offered in terms of available and suitable employment. And again, and the defense agreed with this standard in Zimmerman, a reasonable probability that she's going to obtain employment on a regular basis with this one employer. In light of these attempts, it's their burden and they just haven't made it. And the other thing I would note along those lines is that there's a lot of case law that talks about the remedial purposes of the workers' compensation statutes, and ultimately we're dealing with a statute here. And under that case law, and specifically the Henderson-Jones case at 233 Ares 188, the purpose of the workers' compensation statutes is supposed to be remedial and designed to provide compensation for injured workers, and appellate courts should apply a liberal construction of these statutes to effectuate that purpose. I think in light of that remedial purpose, in light of the employer's burden, and in light of a job search that there's nothing more that she could have done to maintain employment and secure it, that this job just wasn't reasonably available to her, Your Honor.
You mentioned the fact that she either took or tried to take a keyboarding job somewhere?
She went to vocational rehabilitation, which is voluntary, and she took some courses, but she was having trouble with the keyboarding. It's a data entry type position that she wanted to obtain a job in that field. Unfortunately, she ultimately couldn't complete it, but she wanted to. She, as I recall from the record, after a certain period of time in keyboarding, she just couldn't do it anymore after 5 surgeries on her hands.
I was under the impression that the doctors indicated that she had full dexterity following the surgeries, and that her hands were effectively fully functional. That's not the case?
Well, Dr. Guidero was the defense independent medical exam doctor. I know that he did render opinions that she could go back to work full duty with no restrictions. However, there was a functional capacity evaluation done in 2011, which said that she could only do manual dexterity tasks for short periods of time and did impose restrictions. Similarly, her own hand doctor, Dr. Mellinger, said that she could only do part-time work it's at, I believe, Appendix 3 in a report. Plus, he adopted the findings of the functional capacity evaluation of 2011. And so there's really a split in the evidence, respectfully, Your Honor, on that issue. And, I understand that we look at the ALJ's findings regarding credibility and things like that deferentially, but this is a woman who had 5 surgical procedures on her hands, and I would submit that some restrictions are not unreasonable. Your Honors, the bottom line on this issue is that, again, in light of this massive job search, this one job that was offered by the employer, they have not met their burden of showing that it's reasonably probable that she would obtain this employment.
But your position is that the ALJ abused its discretion in so finding.
Our position is that there's insufficient evidence to support this award, that the evidence of one position in Williams is not substantial enough to support a finding that she could work in this position full-time and and that she has some earning capacity. That it's similar to Zimmerman, where one job was found and the court said that it's not probable enough that one job reflects this person's earning capacity. And similarly here, especially in light of the Arizona Supreme Court's language about injured workers being the last hired and first fired, one singular job, it's just not substantial enough, and that she should have that this award should be set aside on that basis. Your Honors, with regard to the second issue, the failure to resolve factual disputes, the Arizona Supreme Court in Post has said that ALJs should explicitly resolve factual disputes regarding important and material issues. Here, at paragraph 13 of the decision, the ALJ stated that there was agreement that Ms. Calder could go back to work full-time. And the problem with that is that there is an obvious conflict in the record on this, that Dr. Mellinger, her hand doctor, testified that he adopted the findings of the functional capacity evaluation, which clearly stated that she could only do part-time work. And in addition, he authored a report dated May 5, 2010. It's at Appendix 4. I may have misstated that earlier, of petitioner's brief, that clearly states she can only do part-time work and gives her restrictions with regard to her hands. Maybe the clearest example of failing to resolve a factual conflict is to not even recognize it. And this ALJ just did not recognize that conflict, and that statement is just incorrect, that all of the doctors were in agreement on this. Dr. Mellinger, the plaintiff's hand doctor, and Dr. Guidera, the defense IME independent medical exam doctor, could not have been more at odds on this issue. And this is a major issue, because if Ms. Calder, can only do part-time work, then the one position at the Grand Canyon Railway is no longer suitable, because according to Mr. Mayer, the defense labor market expert's report, that is a full-time position only. And so it's a major issue. And of course, if there's only part-time employment that is appropriate here, under any circumstances, that is going to reduce her earning capacity and be a difference, frankly, of hundreds of dollars a month to Ms. Calder in terms of an award. And so it is a very, very important issue that just wasn't resolved. And frankly, the award as it is based really on a factual misstatement of the record, because there is a dispute there. And under the Supreme Court in Post, the ALJ needed to resolve it, and she didn't do it. And similarly, that factual issue regarding medical issues, or dispute regarding medical issues, is important because without the judge resolving the conflict between Dr. Mellinger and Dr. Guidera with regard to restrictions on the hands and full-time versus part-time employment, we have no idea what the baseline is if there's ever a reopening of the case or a rearrangement. For example, if the applicant's condition changes, which affects earning capacity, either making it, increasing it or decreasing it, the analysis is, well, has her medical condition changed from the findings in the award? And if we don't know if this judge is adopting Dr. Mellinger's findings or Dr. Guidera's findings, we don't have a baseline upon which to make a comparison. And it's impossible to make that determination. And in Post, the Arizona Supreme Court said the same thing on that record. And this is really a central and material issue. The third area where there was a failure to make a factual finding is on the length of the commute that Ms. Calder would have to make from her residence to this job in Williams that was offered. The defense expert says 42 miles from Seligman to Williams. The problem with that is that she doesn't live in Seligman. It's undisputed she lives 12 miles outside of Seligman. The applicant testified 65 miles from her residence to Williams. It's really significant because in both the Florida case and Minnesota case that are cited in petitioner's brief, 60 miles is too long a commute, 65 miles is too long, such that those jobs were not available. Plaintiff's expert or the claimant's expert said that 50 miles is the longest commute that would be reasonable, and even the defendant's labor market expert, Mr. Mayer, said that Flagstaff would be too far at 77 miles, that's probably too far, although he wouldn't definitively commit. The bottom line is that we don't know if this ALJ thought that the commute was 42 erroneously or 65. She didn't make that finding. We're left to guess, and it's an important issue with real legal significance because a 65-mile commute under the Minnesota and Florida cases and the expert testimony in this case I would submit to your honors is too far, is not reasonably available to her, and is another reason why she is entitled to a total loss. We would ask respectfully that this award be set aside, and if I could reserve the rest of my time. Thank you very much.
May it please the court, counsel. My name is Casey Kurth. I'm the attorney that represents the respondents. I'm the attorney that actually litigated this case before the Industrial Commission. And looking at the big picture, we have a unique case with a unique set of facts. We have an injured worker who has two injuries, one to the hands, one to the back. We're attempting to determine their earning capacity in light of that fact, and we also have to take into account the fact that they live in a remote area. And the fact that they live in a remote area means that we're dealing with a smaller labor market, and it also accounts for why Calder had to drive for her employment before the injury. In addition, you also have to take into account that Calder's complaints in regards to her symptoms in her hands and her back was specifically found not credible. This case does not neatly fit into the statutory and case law. The Commission's award is not perfect, but I submit to you that the Commission's award is consistent with the law, and it is supported by the evidence of record. When you look at the Commission's award, they awarded Calder $605.06 per month for her unscheduled permanent disability. That is based upon full-time employment as a ticket agent at the Grand Canyon Railway in Williams. That is clearly based upon the opinion of labor market consultant Larry Mayer. It's outlined in his July 28, 2011 report. That in turn is based upon the restrictions of Dr. Gaidara, who said that there are no restrictions and that she's capable of full work, as well as the restrictions of Dr. McLean.
Well, Mr. Kurth, the council suggests that the labor market consultant opining and the ALJ finding that there was one position that would be suitable within the geographical limitation is insufficient as a matter of law for your client to carry its burden. Could you comment on that?
Certainly. I respectfully disagree with that. They cite the case of Zimmerman in support of that proposition. And if you read Zimmerman, Zimmerman does not hold that just because there's one job available, that does not meet reasonable availability requirements. Zimmerman is an odd lot case, first and foremost. Zimmerman is a person who was severely disabled from pre-existing juvenile arthritis. This is, in Zimmerman, what it did was it laid out for us practitioners before the Industrial Commission a new way to prove loss of earning capacity. Zimmerman said that the one job that was presented, we don't know that the employer would even consider hiring that person. We don't know that the employer would even consider that person a qualified applicant and or give them equal consideration with all other qualified applicants. So the Zimmerman court then outlined certain things that we as practitioners before the Industrial Commission have to take into account. The number of positions, the competition for that position, the permanency, and will they be given equal consideration? So I respectfully disagree that one job in one labor market is not sufficient. We're dealing with a remote area. We don't have the benefit of more jobs.
Is this a little different than Zimmerman? Because not only is it just one position, but it's the uncertainty that was present in Zimmerman about whether the job would be offered or not. Aren't we a little further down the road here where the applicant here has actually applied with the company, as counsel suggests, 12 times, and including presumably for this very position, and was turned down?
Well, I think that's an interesting point, Your Honor. According to what counsel said, she's applied 157 times. So 157 different applications, and we have no job from that. I think that suggests as to the quality of the search for employment. We also know that how a person presents themselves has to have some impact on it, whether that's online, whether that's in person. If your complaints are found to be not credible, your complaints about your hands and your complaints about your back, which affect your ability to work, are found not credible, and you're presenting yourself as though you have restrictions to your hands and your back, that is going to affect whether you're hired for a job, I believe. So So I think how you present yourself for the job is important. Do I know how she presented herself for the job? I really do not. But I submit 157 applications and no significant job offers. That's startling.
Okay. I think I understand your position. Do you think that evidence, the implications from all of that is that the evidence was sufficient?
I think the evidence is sufficient, Your Honor. It's supported by the labor market consultant who contacted the railway, and there are two separate positions. And if you look at the decision upon review, the decision upon review bases it at $605.06 per month based upon that ticket agent job at the Grand Canyon Railway in Williams. So we're not getting those crossed. It's clearly separated on that.
Do you agree with counsel that the issue of whether those positions, whether the applicant can work part-time or full-time, affects the availability of those positions?
Well, I guess I would agree with that if there was any evidence whatsoever that she couldn't work full-time, and or if the judge didn't resolve the conflict in the evidence implicitly in the decision. The judge issued a decision that's based on Mr. Mayer's opinion about full-time employment. Clearly, we can look through that and see that Mr. Mayer's opinion, as outlined in his testimony and as outlined in his July 28, 2011 report, is based upon the restrictions of Dr. McLean and Dr. Geidera, both who said full-time. So I think it's not an accurate statement. Clearly, we know that the judge resolved the conflict in the medical evidence in favor of the opinions of Dr. Geidera and Dr. McLean, and she's capable of working full-time. I would also submit to you that if you look at the record, the testimony of Dr. Mellinger, the testimony of Dr. Norris, at no time did they say she was restricted to 20 hours. In fact, at no time were they even asked the question. So no, they never rendered an opinion restricting her to 20 hours. That is not a conflict in the record as I see it. There may be some note buried in there before she was found stationary, I believe, that mentions part-time employment. But at no time when Mellinger is in front of the court or over the telephone does he testify that she's restricted to 20 hours of work. And Dr. Geidera addressed that functional capacity evaluation. He talked about how it's bereft of any objective data. So I do not see that there's a conflict between full and part-time employment. And if there is, it was resolved in favor of Dr. Geidera and Dr. McLean.
Counsel said that the court failed to resolve, and these are my words, not his, but I hope this is fair, that the trial court failed to resolve the disparity in the positions of the IMEs. Do you recollect that
I do.
comment? And here's my question for you. Is it necessary for the court to resolve the difference or simply accept and act upon testimony that it finds the most credible? Do you understand what I'm saying? Does she have to sit down as an IME intervener and mediate the difference, or does she simply take the evidence that she finds the most credible and utilize that in her determination?
Well, I think that's a good question. Would it be nice if they did that? If she went through and she picked and explained why she picked a doctor and explained it, that would be helpful. But I don't think it's necessary because I think with post, you can figure out the factual basis for this decision. And it's clearly based upon Dr. Geidera and Dr. McLean. If I could go back to a point I think you touched on, that there was some the judge talked about some agreement between the doctors. When Dr. Mellinger testified on cross-examination, his last examination of the hands was normal. Normal strength, normal range of motion, normal. Exact same thing what Dr. Geidera said. Dr. Mellinger, he briefly touched on the FCE. It struck me that he didn't completely read it, but at no time does he then restrict her work to just 20 hours per week when he's called to testify.
And this is her?
This is her attending physician. If you don't mind, I would like to address the 5 surgeries. 5 surgeries sounds pretty serious, but we're talking about 5 surgeries in which 2 are carpal tunnel surgeries. 3 are trigger finger releases. These are procedures that Dr. Geidera testified that people recover from typically without any permanent impairment. And pursuant to the 5th edition of the AMA guides, there would be no impairment for the hands. But pursuant to the 6th edition, which was in effect at the time this was litigated, there's a 1% impairment to the hands.
Circling back to the point you were making before, and I want to see if this is your answer to counsel's concern about this, what he characterizes as a conflict, unresolved conflict in physical limitations as with an unresolved conflict, that there's nothing, as he said, no baseline established against which a subsequent petition to reopen or a petition for rearrangement could be measured.
I completely disagree with that analysis. If you're looking for reopening, you're going to look at the report upon which closure is based. And you have, pursuant to the statute, and I believe it's 1061H, you have to establish objective evidence of a change in physical findings since the case was closed to reopen. So what you do is you compare the medical report upon which closure is based to the medical report upon which reopening is based, and you see if there's a change in objective findings upon examination. So no, I completely disagree with this. This decision does not have that impact. In regards to rearrangement, which is a slightly different issue, then you're going to have to prove some change either in your physical condition, and again, we would look at that closure report and or the testimony of the doctors, and we would look at maybe a change in economic circumstances. So no, I disagree with that analysis.
So the reference can go back to the last medical exams or the closing reports as opposed to the findings of fact of the ALJ.
Well, if you're looking for strictly for reopening, that's exactly what would happen. It would go back to the last medical report. I think for rearrangement, you could go back to the last findings of the ALJ. More likely than not would be the appropriate way to do it. And I think as you look underneath it, it's clearly based upon the opinions of Dr. Geidera and Dr. McLean.
That was just what I was going to ask you, but if there's a conflict in the evidence, and the ALJ hasn't said whose opinion she's basing it on, aren't you going to have to go back to the, I mean,
If I could address that, I think you're right. There is there was somewhat of a conflict in the medical evidence, but when you look at Post says that we're supposed to look at the facts, we're supposed to look at the case and see if we can determine what's the factual basis for that finding. Well, the finding is $605.06 a month full-time employment as a ticket agent at the Grand Canyon Railway in Williams, and it's based on Mr. Mayer's opinion. Mr. Mayer's opinion, he stated this in his testimony, as well as in his report, is based upon the restrictions of Dr. Geidera and Dr. McLean. So I think it goes without saying that she resolved the conflict in the medical evidence in favor of the opinions of Dr. Geidera and Dr. McLean, and if this came back on a rearrangement, that's exactly what I would argue. If I could go on, then what I would like to address is also the relevant labor market. I will admit to you, I do not remember Ms. Calder testifying that Williams, where she lives, is 65 miles away from Williams. The first I saw of a mileage calculation by Calder's side is in the reply brief. And I submit to you, that is not evidence. That is not in the record. They request that you take judicial notice at one point, and that at another point, it sounds like they're taking that back. But judicial notice, in my opinion, is something that you should bring in front of the trial court so that the trial court can take this into account. There's simply no good reason why that couldn't have been brought out during the hearing process. And so I think to try and bring it in now in the reply brief is inappropriate. It's not evidence, and it cannot be considered by this court. Nathan Dean, who was Calder's expert, said that the relevant labor market is Seligman and the surrounding area. He described the surrounding area as 50 miles. My labor market consultant, Larry Mayer, he looked at it. He testified it's 42.5 miles. Right or wrong, that's what he testified to. If it was wrong, that was the time for them to address it. And it was not addressed until much more recently. And then, if I could go, well, I guess I've covered the conflict in the evidence, the relevant labor market, and whether a single job satisfies the reasonable availability requirement. I look at it as we're here to try and determine whether the commission's award is consistent with the law and supported by the evidence. And as I mentioned at the start, it's certainly not perfect. But it is consistent with the evidence in a unique situation with someone who lives in a remote area, and it's supported by the evidence. It's supported by Dr. McLean's opinion, it's supported by Dr. Geidera's opinion, and it's supported by labor market consultant Larry Mayer's opinion. And for that reason, I respectfully request that you affirm the decision.
okay, thank you very much.
Thank you.
I would just like to respond to a few of counsel's points. Number one, he brings up that Dr. Mellinger didn't utter the words part-time at the hearing, but what he did say is, I agree with the conclusions of the functional capacity evaluation, and that functional capacity evaluation says part-time work is appropriate. Plus, Dr. Mellinger, and it's admitted into evidence, has a report dated May 5, 2010. It's after she was stationary, which was in 2009, that says part-time only. It would be the height of exalting form over substance to say, well, you need to utter the word part-time, but if you say, I adopt a report that says part-time, that there's a material difference between the two. And so I would submit that the counsel's argument just is not valid, and that the fact that Dr. Mellinger thought that only part-time work was appropriate is in the record here. In addition, counsel brings up that, well, how you appear in a job interview and your effort makes a difference in whether you get a job. Everything that he is saying is pure speculation. There isn't any evidence in the record that Ms. Calder did not make an honest effort. There was never a finding by the judge that her effort was not honest in finding employment. Counsel's expert could have asked the Grand Canyon Railway, well, why didn't you hire Ms. Calder? Did she not dress appropriately? Did she not look like she wanted the job? He decided not to do it. So they chose not to try to get this type of evidence. Counsel could have asked for the job applications if he thought they were inappropriate in discovery. There's no such evidence of that. And I would submit on this record, given that she went back to work a couple of times and applied to all these places, that the evidence is that she made a very significant effort to get employment, which unfortunately was unsuccessful. The 65 miles, by the way, is in Nathan Dean's report. He is the claimant's labor market expert and I believe that the claimant testified to this as well at hearing, but it's certainly in Nathan Dean's report where he writes that the claimant, Ms. Calder, told me that it's 65 miles from her house, which is 12 miles outside of Seligman, to Williams. I would also just like to note for the court, I know that counsel argues that it's implicit in the decision that Dr. Guidera's opinions are being adopted here, but here's what's explicit in the opinion. At paragraph 13, this is the original decision. What the judge writes is, as noted by the defendants, none of the doctors who testified in this matter stated an opinion that the applicant is permanently and totally disabled from work, or that she could only work part-time. That statement just is incorrect, again, given the adoption of the functional capacity evaluation and Dr. Mellinger's own report dated May 5, 2010. And with regard to rearrangement, Your Honors, I would ask you to read the Gallegos case, 144 Errors 1, Arizona Supreme Court case, which clearly does say that you measure the change by comparing the facts determined by the final findings and award with those existing at the time of the rearrangement petition. And so this award matters for rearrangement, and there's a big difference between no restrictions and full-time work and part-time work, and pretty significant restrictions on the hands. We ask that you set aside this award. Thank you very much.
Thank you, counsel. We will thank you both for your arguments today. We will take this matter under advisement and issue a ruling in due course. And with that, we're adjourned.
Interesting issue.
Nice to meet you.
Nice to meet you.
No,